me unmute you. Good morning.
Good morning, Judge.
Okay, so
Hi, Logan.
Good morning, Jessica.
I've unmuted Jessica. I mean, Miss Janicek, Mr. O'Neill, and now who else is this lawyer like that? I mean, needs to be talked. I mean, I've unmuted, right? Oh wow.
Paul Leopold, is he on here?
I'm admitting him now.
Okay.
He just joined. Okay, so
There's Paul.
what happened to him? I don't know if I have enough room to look at everybody. Oh, here he is. Okay, he's unmuted.
Morning.
Hey, good morning. And you represent, or you're on?
He's my
I'm with
co-counsel.
Jessica,
He's my like co-appellate counsel, basically.
Just making sure I understand who everybody is. Okay, so Dr. Threets is on the line. I mean, she's here. Okay, so what I thought but those are the three. Those are people who are going to be speaking. And do you guys want a record?
I guess, Paul, do we need a record of this? It's just argument.
At least for the motion to clarify, we will, because we do have some evidence for that part.
Okay. Okay, so I mean, it makes sense to me to argue the motion for new trial part first, right?
Yeah.
Okay, so I don't know how, I gotta admit, I don't know if everybody, the people who are muted can still hear us, right? So they're getting, okay. And is there I'm just admitting everyone because this is the way anybody who asks is coming into the meeting. So, let's see. Shan, let me make sure the court recording. Yep, Shan's here. Okay. I'm going to unmute her for a sec. Okay. Where'd she go? Oh my. There she is. Okay. So Shan, are you ready?
Yes, I'm ready. And if when we identify, we'll just have the attorneys identify first and then the other participants.
But not everybody in the courtroom, just the people, I mean, everybody watching, just the people who are going to be participating in the hearing, right?
Oh, I would have everybody who's watching identify themselves, but I just want to get the attorneys first that are going to be speaking.
Okay. Okay, so this, oops, this is cause number, of course, that's just this one. Technical difficulty. Cause number 159887. And attorneys, would you state your names for the record, beginning with you, Ms. Janicek?
Right, my name is Jessica Janicek, and I represent Dr. Ann Georgelis.
Thank you.
Paul Leopold here for Ann Georgelis.
Mr. O'Neill?
Logan O'Neill on behalf of the respondent, Jeffrey Damon Younger.
Thank you. Are there any other parties or lawyers?
Your Honor, just to clarify, Mr. Stacy Dunlop was the amicus attorney in this case, and then he became the parenting coordinator. So he is, I don't believe, on here. So he sent an email this morning and was worried because he didn't want anyone to think he was a no-show. So I promised I would let everyone know he is not a no-show. He's just now the parenting coordinator, so he wouldn't participate like he used to.
Okay. Okay. But no other well, I guess, and your client is present, correct, Ms. Janicek?
Yes.
And would you, Dr. Georgelis, will you state your name? maybe she can.
And Georgilis.
Thank you. And here's somebody else coming in. What about Mr. Younger? Is he here, Mr. O'Neill?
He is, Your Honor.
Will you state your name as well, Mr. Younger, for the record, so we know, just so we have a record of who all is present?
Jeffrey Damon Younger.
Thank you. Okay. More people. Okay, so those are really the those were all the parties. We've identified everyone that needs to be in the record, except for possibly a couple of witnesses.
Yes, I believe Linda Threets, Dr. Threets is the only other, and Mr. O'Neill, you can tell me if I'm wrong, but I believe that's the only other witness as part of this proceeding.
Okay. And it's okay, no one's invoking the rule or wants to do anything like that, correct?
Well, I don't know. I'm just going to say no for purposes of this.
Okay. And I, just for those of you who are tuning in, who are interested and for whatever reason are involved or here with us, I'm just going to remind you that this is a court proceeding and we are, there is a record and I'm not yeah, I just want you to make sure that everyone understands the rules. There's no videotaping, there's no recording. This is being recorded by the official court reporter of the 301st Court, and that will be the way to preserve this record. And otherwise, you guys, there is a prohibition against recording or videotaping in these proceedings. So, and I'm going to keep all spectators or everyone who hasn't been mentioned just on mute during this hearing. Okay. All right. And with that, Ms. Janice, I mean, the motions, I usually would take them in the order in which they're filed, and technically, let's see, who's this first? I think Mr. O'Neill, your motion was filed first. Is that true or no?
That's correct, Your Honor. We filed on February 13th.
Okay. Yep. So do you want to go forward with your motion to clarify first, or your motion?
Certainly. May it please the court, Your Honor. The first point I'd like to address is the permanent mutual injunction. It is contained in the final order that you signed on January 29th, beginning at page 24. And it is objectionable in that it is a prior restraint on the free speech rights of the father and also the mother. It is patently overbroad and overreaching. And if I can just quote from it briefly. It prohibits the parties from discussing the litigation in the presence of the children or within hearing range of the children named herein, including either parent allowing a third party to discuss the litigation in the presence of the children or within hearing range of the children named herein. But then it goes on to say, making any videos, doing any type of interviews, news interviews, documentaries, television appearances, radio appearances, internet radio appearances, blog posts, social media posts picturing the children, doing live social media feeds of the children, doing any type of post, blog, broadcast, or recording, whether written or electronic, discussing gender, cisgender, transgender, gender fluidity, gender dysphoria, gender identity, whether the children are masculine or feminine. And the court failed to consider any less restrictive alternatives. And we just get into some very serious problems with this because there's no basis or authority in this for this type of permanent injunction in the Texas Family Code. And it also violates the constitutional rights of both parties under the First and 14th Amendment of the U.S. Constitution. It's an impermissible prior restraint on the free speech rights of both parties, and the state has absolutely no compelling interest here. This is not a matter of, safety or well-being of the children. They're not in danger of physical harm or anything. So there's no compelling interest to just trample on the rights of the parents like this. And so on that basis, we find that part of the order objectionable and ask the court to either modify, correct, or reform the permanent mutual injunction based on that, Your Honor.
And thank you. Ms. Janasek, do you guys, are you guys in agreement on this point that you both are complaining of the order, the injunction language?
So I'll let some of this Mr. Leopold's going to argue, but the one thing I will point out just to answer your question is, I think that most of the order itself is overreaching and ordered things that no one asked for because no one pled for those things. I mean, obviously, you can look at the courtroom and see all of the people that are in here. This is made a public spectacle. And the problem is, I do think that the court does have some authority to protect children from becoming a public spectacle. But with that being said, I don't think that we can pick and choose the very specific things that were and were not pled for. If it wasn't pled for, just like most of the other things that were ordered weren't pled for, I absolutely think that it's overreaching and that it should be modified or the entire thing thrown out.
Okay, so, just on the points that Mr. O'Neill just on the prior restraint and on that portion of the whole injunction, the overbroadness, you share that. I feel like your side shares that, doesn't want that in there. Both of you want that out. So point is, you guys agree on that issue, sort of.
Yes, sort of.
Okay. Okay, so, but Mr. O'Neill, are you finished? Sorry, I just took your first point. Is that your main point?
As far as the injunction, yes. And the other thing is, nobody asked for it. Nobody pled for a permanent mutual injunction covering any of those things. I think as a family law practitioner, I'm very comfortable with a permanent mutual injunction about just not disparaging the other party and not discussing the litigation. But other than that, you get into some pretty murky waters when you venture out beyond that. And here, Judge Cooks really took off on a tangent on this permanent mutual injunction that we have in the order. So that's our objection to that, and we would respectfully ask that it be modified, corrected, or reformed to comport with the law, and so we have a viable order going forward in the event of an appeal.
Okay.
My second point, Your Honor, just relates to child support. The court made very elaborate findings in its memorandum ruling dated October 24th, 2019. And I'm going to talk about those later when Ms. Janasek reviews her points. But the court did issue a very detailed memorandum ruling, and it has findings, like 5 or 6 pages of findings. And some of the findings in relation to the respondent father are very inconsistent. And the one that we find objectionable is in reference to child support, the court found that the father was unemployed, that he did not own a car, and that he did not own his own home. Yet it has him paying in this order basically maximum child support for 2 children. And the same thing with his cash medical support that's also in the order that was signed January 29th. He's paying basically maximum child support and also on top of that cash medical support when the court specifically found that he had no employment. And so we're asking that that part of the order be modified, corrected, or reformed under the rules, and that we change that to have his child support at either minimum wage level or something appropriate under the circumstances where he still, the findings are still in effect today until we have some other evidence to show that he's employed or that he has income. I would respectfully submit that the appropriate setting for the child support is under the guidelines at the minimum wage level, which is about $300 a month. And then the cash medical support would probably stay the same. So he should be changed from about $2,000 a month to about $500 a month total child support.
Okay. And those are your 2 points for your motion for clarification or modified, correct, or form, correct?
That's correct. We just raised the permanent mutual injunction and the child support and medical child support, Your Honor.
Okay, thank you. All right. Response. I mean, or you guys want to make your argument now?
I will, if it's okay with the court, I'll respond real briefly to what Mr. O'Neill said, and then I'll let Mr. Leopold take our motion. The problem, Your Honor, is when we were here, the days are blending together at this point. Sorry. But when we were here, I guess weeks ago, we filed a motion to conform the jury verdict and a few other things before the order was entered. And one of the arguments that we had made was on calculating the child support, because yes, the court found Mr. Younger was unemployed, but the court also found that he had resources of over $100,000 that he had raised through these GoFundMe and other accounts. And we had argued that the child support should actually be increased. And at the time, there was an argument that was made by Mr. O'Neill and Mr. Younger that, hey, we didn't ask for that. We didn't plead for that. So the child support should stay as is. We went back and looked at Mr. Younger's pleadings. He only asked to have Dr. Georgelis pay child support. So I am absolutely all for agreeing that if you didn't plead for it, you don't get it, because then it takes us back to, well, there was no pleadings on file for Mr. Younger to become a joint managing conservator. There was no pleadings on file to take away my client's right to designate the primary residence of the children. And if we're going to get into that, I have no problem with us going back to the root of, if you didn't plead for it, you don't get it. And so the order should be corrected. But it's hard to argue that there were injunctions that weren't pled for, so we should take those off the table. And they didn't plead for a change in the child support other than my client paying for it, yet we should change Mr. Younger's child support. So I feel like it's a very inconsistent argument. And so for those reasons, I would ask certainly that if you're going to look at both motions, I absolutely think this order needs to be corrected. I absolutely think most of the things in this order need to go back to what was actually pled for. And so I would ask the court to do that. And then I can turn it over to Mr. Leopold if you would like us to argue our motion.
So what was child support before?
It was what was in the prior order. So it didn't change. So, and I don't have it in front of me. Logan, do you have it in front of you?
Yes, it's like $1,935 a month or something, Your Honor.
What it was?
Yes,
And that's what it is now. It didn't change.
Is that true? So the child,
it was just what was in the prior order from 2016.
so the judge, this order didn't change child support,
It did not.
No.
but your client tried to lower child support, or no request to change child support except for request child support from mom.
At trial, we were seeking appointment as a sole managing conservator and asking that the mother be the possessory conservator in order to pay child support and obtain legitimate medical insurance coverage.
So essentially this order denied, well, it just kept things with child support the way they were, denied any change for Mr. Young.
That's right. The court maintained the prior appointment of the parties as joint managing conservators.
So we really, I mean, if we were the order, let's just say, if I were doing the order, I would not, I mean, if I were making the order, I generally don't put in things into a modification order that I didn't change. Like I don't okay. I don't know who it is, you guys. Okay, let's see. I'm working. Remove. Do you want to remove? Yes. He's gone. Okay, well. I guess that's one of the problems with Zoom, because they've said Zoom bombing, but I didn't think that we would get it. I will not let him back in. But now 3 more people have called back or admitted, and since the hearing's already underway, I'm going to decline to admit them right now, if that's okay with you, because we're almost, yeah, I don't know. I mean, I could admit them. It's just late for a hearing. You can't tune in at 9:51. We're crowded. Okay. Well, where were we?
Let's
I believe
see.
you're talking about just a denial of any change in child support.
Oh, right.
Oh, you asked, and I think Mr. O'Neill, I think he replied to this, but you asked if there was no pleading on file by Mr. Younger to reduce his child support.
Correct. So the judge the order just restates it. It's really not like she ordered new child support, but does the order that I signed, is it one that says any provision not changed by the prior order stays the same?
It does, yes.
So we could take out child support because it wasn't changed without hurting anything, because it would be one of those things that wasn't modified, so it stays the way it was.
I think it has to be in there because there is a modification to it. But what Judge Cooks did was she said the child support she said that the dad will pay child support is what she said. So she didn't give a calculation. That's why we had an argument about it. Then she said, though, that dad's child support would be abated, but it's based off of this 50-50 schedule that's supposed to be determined by the family counselor if they ever get there. And so basically, if they get to a 50-50 schedule, then his child support is changed. So I don't know if I think we still need to have that part in there.
Okay. But the bottom line is that wasn't a new thing. It's really, you're going to really be arguing, Mr. O'Neill, your real argument is that was just improper based on the evidence. I understand what you're saying.
Yes.
To leave it that way. Okay. All right, then are we ready to go on to the to the motion, to the actual body of your full motion for new trial and to correct or reform, Ms. Janison?
Yes, Your Honor. If it pleases the court, I'll go ahead and turn this over to Mr. Leopold and put my Zoom on mute.
Okay.
Thank you, Judge. May it please the court. I'll first ask the court to take judicial notice of the file. I think everything the court needs is in the file.
So noted.
And the background motion for all of this is in our motion. I think we don't need to spend any time going through all the details of everything. And we did submit a proposed order. It's just kind of a checkbox format, so you can go through and check if something's granted, denied, why, what you're modifying, things like that, just to help simplify things in the state that we're in.
Thank you.
So for the motion to modify, we have a few points. I'll just go through them point by point. The first one is that the jury answer, the judgment should conform to the jury answers. So here the jury answered yes to sole managing conservator, and then answered dad should not be sole managing conservator. Under Family Code 105.002, those answers are binding on the court. The Supreme Court of Texas has held that a court can't contravene jury answers that go to conservatorship. Several courts around the state have all held the same thing. And I think most on point, and we provided these cases to the court on Friday of last week, the N. Ray Walters case that we cite to is very similar to what we have here. In that case, both parties had pleaded to be joint managing conservators. The jury charge that was submitted said, the first question was there a modification or a substantial change, that there should be a modification? And if so, who should be the managing conservator, mom, dad, or both? Even though both parties had pleaded for joint managing conservator, the jury answered dad in that case. Mom appealed, and the Court of Appeals said, you didn't object to that jury charge when it was submitted, so you waive any issue about the jury selecting a sole managing conservator. And that's basically what happened here. Even though mom and Dr. Georgelis did not plead for sole managing conservator, that's what the jury charge allowed for, because the jury answered yes, there should be a sole managing conservator. And so there wasn't any objection. In fact, dad's jury charge, proposed jury charge that was filed with the court on October 14th, 2019, was even more broad than what Judge Cooks changed it to. His second question was, who should be sole managing conservator? Judge Cooks just changed that to be, should dad be sole managing conservator? The jury answered no, and because the court only has jurisdiction over mom and dad, the two parties to this case, the only other party the court can grant sole managing conservator to, in conformity with the first answer, is mom. So I think under the binding court or the binding jury answers under 105.002, the court can modify to conform to those jury answers and name mom as the sole managing conservator. And I don't know if you want me to go through all of our points or go back and forth on each point as we go through.
Well, you can do it. I mean, which would you prefer, Mr. O'Neill? I'm fine to go all the way through and then let you respond.
Your Honor, I'm happy to do it either way, but I can certainly reply to each point as we go if that's easier.
Okay. Okay, well, go ahead then.
Well, this is the argument that mom made in her second amended motion to conform to jury verdict, which was argued before you in an evidentiary hearing, January 29th, 2020. So we've already been through this. And that's why Friday I submitted a proposed order on that, because I just looked at the docket sheet and realized you granted our motion to enter and signed a final order, but there was no order signed on mom's second amended motion to conform to jury verdict. And so I think the appropriate thing to do is for an order to be entered that denies that after that hearing. The reason that that motion was denied then, and it should be denied today, number one, mom never had any pleadings asking to be appointed sole managing conservator of the children, nothing. She submitted no jury questions asking for that. She did not object to Dad's questions that were submitted and ultimately used, although modified. She had the opportunity to ask for leave to file a trial amendment under Rule 66 of the Rules of Civil Procedure. She didn't do that. She argued to the court and the jury for joint managing conservatorship all the way through the trial. So there's also an estoppel argument that I would like to make, that you can't just totally do a 180 and change your position after you've put on evidence and made arguments and everything else for one thing, and then suddenly change it, say, no, I'll take something totally different. Mom also asked the court to adopt Dr. Albritton's recommendations. He was the court appointed custody evaluator in this case, and he filed like a 85-page report, and his recommendation was for joint managing conservatorship. And Mom asked the court to adopt that. She argued that to the jury. She also filed a requested relief with the court that asked for joint managing conservatorship. The jury never decided who had the exclusive right to determine the children's residence. The jury didn't change that. They had one question, they answered it, and they were done. Okay, there's nothing contravening the jury verdict. Their verdict was simply that they didn't want to appoint Dad as sole managing conservator, period. There's nothing inconsistent about the questions. The court doesn't have to harmonize them, as Mom says, and this argument has already been overruled and denied. And so I would ask the court to sign the order I e-filed Friday. It's just a very short order saying that Mom's second amended motion to conform to jury verdict is denied. Thank you.
Judge, just a couple of points. Even if the motion to conform was denied, the final judgment has been signed now, and we're asking the court to modify that. Just like in the N. Ray Walters case that we cite to and that we've provided to the court, all similar things happened. Neither party asked for SMC in that case, but the jury still appointed an SMC, and that's what the final judgment reflected, and the Court of Appeals affirmed it. The jury had two questions here. The first one was, should there be a sole managing conservator? And they said yes. That's binding on the court. So I don't see how the court can get around 105.002 and a binding jury answer that says there should be a sole managing conservator by appointing joint managing conservators. So I think it's binding on the court. It is kind of a messed up situation, but case law has been through this before, and they say you follow what the jury says. Thank you.
Okay. And does that conclude, is that just your other?
That's the first point that we have.
Okay, so carry on.
For our second point, goes through the rights and duties and the possession schedule. This is tied to sole managing conservator. Following the jury's answers to be a sole managing conservator, I think the court would need to follow 153.132 and grant those sole managing conservator rights and duties to Mom, and then put in a possession schedule in accordance with 153.251, where we have a sole managing conservator and a possessory conservator. I think this gets a little bit more into the liberal versus strict construction of family law pleadings. The Texas Supreme Court has made it clear that family law pleadings are liberally construed. There was a short, maybe 18-month stint in the 80s where they were strictly construed. Any other current family law cases that say they're still strictly construed only cite to general civil cases. So I think looking at it liberally, once the kids are in the custody of the court, as far as custody, possession, those types of things, the court can order anything that is contemplated by that, which the Leathhold versus Plass case says. So I think that just ties into the jury answered yes to SMC. Custody was in the jurisdiction of the court. So the court can make mom SMC according to the jury's answers. If you are looking at it in a strict construction, then like Ms. Janicek said earlier, lots of things weren't pleaded for that are in this final judgment, so those all need to be modified then.
Okay. Do you want to respond to that, Mr. O'Neill?
Yes, Your Honor. The court always has to do the rights and duties. That's not something the jurors can ever do under section 105.002. The jurors can decide conservatorship and who has the right to designate the children's primary residence, and that's it. And so in any case, the court has to fill in the blanks there on the rights and duties. And again, we're going back through that where we're arguing about what the jury meant. The jury questions have to be taken together. The first one is just kind of a prefatory question as to the second one. So they have to be taken together. You don't just grab the first one and say that's what they meant. So by that logic, you know, they meant for mom to be sole managing conservator. No, that's not what they said. And that's arguably not what they meant from dad's perspective. And I had to point out, you know, what this is really all about goes back to the prior order, which appointed the parties as joint managing conservators, but the court gave mom all the exclusive rights to make medical and psychological and psychiatric decisions. And so if you're wondering, what is this, you know, what's the underlying argument here that nobody's talking about? Well, that's what it is. That's what the big fight was about, was mom had the exclusive right to make medical decisions, and she was making decisions that dad felt were very harmful to the boys. And so the judge in this case, Judge Cooks, solved that problem by just making all the rights and duties relating to medical decisions subject to the agreement of the other parent. And we think that's entirely appropriate here with this situation.
And Judge, we'll just cite you to the In Re Reader or Writer case that we cite to that says that sole managing conservator is not merely a descriptive title. So in other words, even if you name one party a sole managing conservator, that doesn't mean you can just go back through and then make all the rights and duties in the possession schedule as if there is no sole managing conservator. Now I'll move on to our next point.
Okay.
For the impermissible delegation of authority, Mr. O'Neill did provide the court with the JSP case. Hold that up real quick. Which, and there are some cases that say, yes, you can delegate some of that authority, but even in the JSP case, I believe it's similar here, that it's an impermissible delegation of authority because the order as it stands now doesn't have all of those safeguards in place. It has a January or June 2020 timeline, but just like in JSP, it doesn't provide for any status hearing or status conference with the counselor. It doesn't provide any guidance for the counselor, any of those checks and balances that even the JSP case says need to be in place if you delegate any of that authority. And I think most importantly, it's not specific enough, the way that it's worded currently, to be enforced by contempt, which whatever kind of order it is, if it's not enforceable enough to be, or if it's not specific enough to be enforceable by contempt, then it's an abuse of discretion. So we were just asked to either take that delegation out or put in those safeguards that even the JSP case say need to be in there.
Sorry for 1 second, guys. Before, does anyone remember the name of the guy, the photo bomber? Just so that the Zoom bomber, just so that I know. Totally did not see his. I mean, I didn't retain that information, but does nobody remembers that? I guess that's why the court reporter wanted me to take everybody's name of all the participants, I mean, all the spectators too, because I didn't think about that. But okay, so nobody remembers his name. Well, if any of the other spectators know, or if you guys find out that anyone knows the name of the person, then I would like to let you know, because he's in serious contempt of court, and I'm gonna try to, I mean, if I can get his name, I would try to follow up on it.
Please do, Your Honor. I would say that should be some kind of a federal crime to Zoom bomb in the middle of a live court proceeding.
It's bad.
Yeah, I'd heard of that, but I had not experienced it yet. So
Glad I could help you with that.
thank you.
I could have gone a long time without it. Okay. Oh, wait. You should go. Huh. Okay. Sorry. So I just wanted to say that in case anybody else forgot or someone knew. So you may continue, Mr. Leopold, if you have more on that on your
I
motion.
have two more points. I don't know if Mr. O'Donnell wanted to address that, the delegation of authority.
Oh, right.
Certainly.
Okay.
The only thing that they're complaining of is that the counselor was delegated the authority to decide when the 50-50 equal times of possession would begin, either in January or June of this year. That was just the one thing. So if we look at the order that was entered on January 29th, it was very carefully drafted to be enforceable under either scenario. On page 8, subparagraph C, it's parents who reside 100 miles or less apart, and then in bold it says beginning on October 22nd, 2019 until commencement of equal times of possession as provided below. And then when we go subparagraph D, upon commencement of equal times of possession as determined by the counselor, either January 1st, 2020 or June 1st, 2020, then here's what it is. And I lay out the alternating weeks in standard format, enforceable language. I'm very well experienced and have the scars to prove it of a lot of contempt dockets on possession and access and child support and things that are normally enforced by contempt. And so I very carefully drafted this to implement it either way. The JSP case is relevant here because there are times where a court can delegate a very limited amount of authority in certain unusual circumstances like this. In JSP, it was a very similar scenario where the court delegated to an outside third party some oversight over the visitation and some decision-making authority over what visitation was going to be appropriate with this guy. The dad in that case had a closed head injury and was somewhat impaired. And so the court there needed help with when it was going to be appropriate for him to have possession and access. Here in our case, Judge Cooks basically envisioned a pure joint setup with equal times of possession and also no child support. So it was a very significant change. And Dad's position is simply that that was the decision. It was just delegated to the counselor as to exactly when it was appropriate to effectuate that, whether January or June. So that's a very, very narrow and limited delegation of the authority. And we feel it in this case, which was very complicated, it was entirely appropriate.
And I think the possession schedule itself, I think, is enforceable that way, but the delegation to the counselor and what the counselor is doing, that's the part that's unenforceable, because it only gives that January or June time frame, and it's missing any status hearing or status report, just like the JSP case was missing. It's missing the other things in place as part of that delegation to make that part enforceable and be able to show that it is in the best interest of the children.
Thanks.
Our next point is on the injunctions. We talked about that some. We agree they should be taken out. We cite to the In Re AAN case, which goes through that the family code doesn't actually contemplate permanent injunctions under Title V. It contemplates temporary injunctions, but because permanent injunctions are not contemplated under Title V, the In Re AAN case held that if you want permanent injunctions, you have to plead it and you have to prove a wrongful act, imminent harm, irreparable injury, and the absence of an adequate remedy by appeal, just like in other civil cases. So in addition to the prior restraint on free speech, I think this is just another point of why those injunctions should be taken out.
And I've already heard, I think, both arguments on that. So let's just move on to your next one.
Our last point is about the parenting coordinator. And my understanding, and I wasn't part of the previous hearing, so Mr. O'Donnell and Ms. Janicek can weigh in on this. The final order itself doesn't actually remove the amicus, but I believe that was the order in the court at hearing. And so either way, I think there's a problem having who was the amicus or is still the amicus as the parenting coordinator. Under 153.605, the amicus can't be the parenting coordinator. Under 153.606, actually starting with 153.610, the parenting coordinator has to qualify. There was never from my understanding, there was never a hearing, notice of a hearing to appoint a parenting coordinator. And Mr. Dunlop did not provide any of those credentials that are under 153.610. And then I think the order itself has a problem in allowing the parenting coordinator to make the decision for the parties. Under 153.606, it cites to the ethical guidelines for mediators put out by the Supreme Court of Texas that specifically says the mediator cannot make the decision. And the coordinator acts similar to a mediator. If the parties cannot make a decision, they come to the coordinator to help to resolve that problem. But under all of the authority that the coordinator has, none of them say that the coordinator can make the decision. And the ethical guidelines for mediators specifically says they cannot make the decision. But the order here says if the parties go to Mr. Dunlop and still can't resolve their dispute, then he makes the decision for them, which I think completely contradicts the family code. So either we need to take out that parenting coordinator, take out that provision that he makes the decision. I think having Mr. Dunlop in place also violates 605, that the amicus can't act as the parenting coordinator. So we need to have a hearing, notice in a hearing to appoint someone else and then allow them to provide their credentials that are required under 610. Thank you.
Yes, Your Honor. Mr. Dunlop did serve as the amicus throughout the modification proceeding. At Mom's request, he was appointed, I believe, in the summer of 2018. And clearly he cannot serve in a dual capacity under the family code provisions that Mr. Leopold is citing. However, my argument back in January was the same as today. The amicus appointment basically expired when the case was over. And so if it's necessary to formally discharge him as amicus and confirm the appointment as parenting coordinator, I think that's appropriate. I will reluctantly agree that my understanding of what a parenting coordinator does is they're not supposed to make decisions for the parties. And so, that's statutory. They're just supposed to assist the parties. So I do agree on a very limited basis that the order does need to be tweaked a little bit to clarify that his role is in accordance with the statute. And also that, you know, Mr. Dunlop is an experienced family law attorney, so I think he meets the qualifications, which if there's any discrepancy with all those classroom requirements, those can certainly be waived by the court, and he can serve in this capacity purely on his experience. I think the problem is that, you know, again, mom is objecting to him just because she doesn't like his position. And, you know, so she wants somebody else to get another bite at the apple, and I don't think that's appropriate. And also, I have to notify everybody, I have a guy with a leaf blower standing outside my window. So if there's some noise here, I'm hoping it won't last very long.
We'll make you mute. We'll mute you if there's a loud noise. But you'll still be able to hear. We just won't be disturbed. I know the perils of Zooming from home. You cannot control the noises or the bombers. Okay, Mr. Leopold, do you want to wrap up?
Yeah, so briefly on that point, the reason we're objecting to that point, to the parenting coordinator, is for him making the decisions on behalf of the parties, which I believe Mr. O'Donnell said he agreed on that limited point. And I believe under 153.610, the court can waive those requirements if the parties agree to it. If the parties don't agree, then the court would still have to have that notice and hearing so that whoever would be appointed coordinator can still provide that information. Moving on to our motion for new trial. First, with insufficient evidence, obviously Your Honor didn't try the case. So I think you would have to either go back through the record to see what evidence was presented. I don't know how else you could do that, but that leads into the findings of fact portion that we have, that under limited circumstances, a successor judge can issue findings of fact. Under Rule of Civil Procedure 18, the successor judge can make findings of fact if the original judge dies, resigns, or is disabled. Under Civil Practice and Remedy Codes 30.002, the successor judge can make findings of fact if the judge dies or the term of office expires for the original judge. But out of that, the Dallas Court of Appeals held in Larry F. Smith versus Weaver Company, that we cite to and have provided to the court, that outside of those specified times, the successor judge cannot make findings of fact. And the Dallas Court of Appeals explained in that Larry F. Smith case that if there are no findings of fact, which Dr. Georgelis has properly requested and filed the notice of past due findings of fact, if there are no findings of fact, it's presumed harmful if the appellant has to guess as to why the court ruled against her. There are several findings in the court's rendition, but as the Dallas Court of Appeals points out, those are not official findings of fact, so they are not binding on the Court of Appeals. Actual findings of fact under Rule 296 and 297 are binding on the Court of Appeals. So here, because you are the successor judge because of recusal, not because of death, expiration of term of office, resignation, or disability, I think under the case law and under the statutes, you are not able to make those findings of fact. And because you aren't able to make those findings of fact, and because there would be prejudice without them, because we would have to guess as to why these orders are in place, contrary to the jury's verdict, I think that would cause that harm. And so if you could make findings of fact, the Court of Appeals could just abate it to allow you to do that. But under the statutes and the rules, I don't think you can. So in that case, the Court of Appeals would have to remand it for a new trial. So for that reason, and this new trial is all alternative to our motion to modify. But for that reason, I think you would have to grant a new trial rather than allowing the parties to go up on appeal only for it to be remanded for that reason. And I have one more point after that if Mr. O'Donnell wants to respond to that point first.
Certainly, Your Honor. The legal presumption that arises in the event that a court, for whatever reason, is unable to issue findings of fact and conclusion of law is that the party is harmed because they have to guess at why the court ruled against them. And that's a logical thing. And it's like my grandfather used to say, the law is usually what it should be. And there's actually a lot of common sense woven into it. And here is a perfect example. Okay, the court issued a memorandum ruling on October 24th, 2019. It's 7 pages long. 5+ pages are nothing but her findings from the evidence. Very detailed. So in this particular case, nobody, whether it's my client, the father, or Mr. Leopold and Ms. Janacek's client, the mother, has to guess at why the court ruled against them on this or that issue. It's all spelled out in plain English, and it's part of the record. It's her memorandum ruling from October 24th, 2019. So the legal presumption of harm simply does not arise here because nobody has to guess. We all know what the court ruled and why the court ruled the way it did. She spelled it out for everybody. And if there's an appeal, that memorandum ruling goes up with the record to the Court of Appeals, and it's not technically findings of fact, but it's pretty close. It has enough detail where that's what you would have used if you were going to prepare the findings of fact and conclusions of law. And, you know, in the event of an appeal, I would argue that presumption will not apply to this case. There's no harm to the mother because she doesn't have to guess at why what happened did happen. And, you know, that's a very important point because, again, I will reluctantly agree with Ms. Janacek and Mr. Leopold. In this particular scenario, and it wasn't easy to nail down in the legal research, the successor judge cannot do the findings here. They're right. I mean, I traced their footsteps through all the cases and everything, and it's a cure for insomnia if you ever want to brief it, but it's true. You know, you cannot do the findings of fact in this particular case the way it played out with the recusal and you appointed as a successor by the regional presiding judge. It just falls into a crack. And, you know, that
where we all are now, in that crack where I can't do, that's, yes, my hands are tied in a lot of ways, and you guys are with me. I'm sorry. But so we move on that one. I understand. And so your last point, Mr. Leopold, sorry you guys, but we are running out of time.
Yep, just a brief response. The Larry F. Smith case also had findings in the record that weren't official findings under Rule 296 and 297. And the Dallas Court of Appeals said because they weren't official findings of fact, there was still the presumption of harm. So the last one, the jury answers are conflicting. I made my argument in the motion for modification. I don't think they are conflicting, but if the court believes that they are conflicting, then the only outcome would be a new trial, because it's similar to like a hung jury that if they can't come to a conclusion, then you have to retry the case. And that's all that I have for that one.
Okay. Thank you. Do you want to respond to that, Mr. O'Neill, or no? Are you fine?
Well, it's simply the argument that we make that they are not conflicting, that under the circumstances where one party hasn't asked for the relief, so you only have the father asking for appointment as sole managing conservator, you know, in a perfect world, if I could do it over, I would just want the one question: should Dad be appointed as sole managing conservator? Because the first question was just kind of the intro. And so now, you know, for Mom to latch on to that first question is kind of hard to take, because she didn't object to it at trial. And, you know, there were so many remedies she could have pursued if it was offensive, if it was objectionable, if she felt that harmed her. Again, the one thing in front of the jury was simply whether Dad could be appointed as the sole managing conservator, and they said no, period. So that's the end of that story. And then the court, as is routine in every single case, has to fill in all the blanks. You know, in family court, we're blessed to have juries in certain limited circumstances, but it's very limited what they can do. And so this case is no different. The court always does the majority of the rulings in custody cases. Thank you, Your Honor.
Okay, so that really concludes the motion, but all the like the post-judgment motions, right?
We do have the motion to clarify, which I think would be an alternative or part of the motion to modify, that Ms. Janicek will call Dr. Threets as part of that.
And because, well, I kind of would like to, I have a hearing at 10:30. I gave you guys were slated for an hour, or yeah, an hour. And so I'm not sure, I wasn't expecting a contested hearing with evidence, because I think I would like to rule on these motions, because depending on the way the ruling goes, then we may not need the motion to clarify. Well, we may still, but whatever. In other words, I think we should probably schedule a new time to hear the motion for clarification where we have the evidence. Or, let me check with Catherine one second. Wait, how long will do you expect that will anticipate it to take, Ms. Janicek?
I don't think it will take long. It's literally just, I mean, I was going to ask Dr. Threets why she's asking for the clarifications of this order, because it was Dr. Threets that came to myself and Mr. O'Neill, and she was asking for basically some more teeth in the order. And I agree with you. If all of it gets thrown out and we're back to square one, then we don't need that. If not, then we do have that motion to get some clarity. And so I don't think it will take very long. But obviously, I understand. I don't want to impede on other people.
Well, and you submitted order for counsel, a proposed order that has the teeth, or just, yeah?
Yes, I did. And Mr. O'Neill's seen it, and Dr. Threets has approved it. So that's the order floating around. That's basically, I just have her here to explain why, as the family counselor, she needs it, because I think she's going to tell you if she doesn't have that, then she's going to have to step out as the family counselor.
So, and Mr. O'Neill, do you agree that if the order stay, depending on the results of today's hearings that motions that we've already heard, you may or may not need this order, but this order, if you do need it, is approved by you?
We object to the proposed clarification on several reasons, several bases, but the first one is simply the expense. What Dr. Threets is contemplating doing is appointing 2 additional counselors, one for each boy. We have twin 7-year-olds that are going to turn 8 next month, and she's wanting to appoint a separate counselor for each boy and have the parties ordered to take them to counseling, one of them twice a week and the other one once a week. And all these counselors, everybody's $250 an hour, plus doing the counseling with Dr. Threets at $250 an hour. We're just talking about an incredible amount of money being ordered monthly, going forward, and it's just not sustainable and not appropriate under the circumstances. So that's our primary objection to the requested clarification.
And I would just say, Your Honor, it's way cheaper than going to court and coming here and having hearing after hearing after hearing. I think the goal is maybe if Dr. Threets has some teeth and she's able to get some things done and get some counselors involved and for this family and have more of like a team approach, which is what she's trying to do, I think maybe we won't be in front of you over and over and over. I think that's part of the goal.
Well, what I was going to say was that could we just, Mr. O'Neill, can we just say, I mean, without, do you feel you need to cross-examine Dr. Threets, or can we just either let me rule on this part by submission if we need it? Or, I mean, if it turns out that I think we're going to need it or not, or do you want to have a hearing where we can have her testify?
Well, I think we're going to have to put on evidence if it comes to that, just because of the expense going forward. I just have to reject that argument. It's the same one I got from Dr. Threets that, hey, this is cheaper than litigation. Well, you know, that's not the standard, the proper basis to analyze this. It's absolutely oppressive, and it's not sustainable for Dad going forward to be just, you know, paying $5,000 a month or whatever it's going to be for counseling. Some counseling is obviously warranted here, and the court made pretty detailed findings about that. And Dad is even participating with a separate counselor, trying to be proactive and get ahead of this. But, you know, that's our primary objection, is just the brutal expense. But I am certainly happy to have the court just do it by submission if we have the opportunity to also submit some additional evidence if necessary.
Because really it's just more like a modification it would be might be more like a modification just to clarify going forward on like how this is going to work, but not necessarily, I don't know, maybe that's wrong. Maybe I just didn't think, never mind.
We filed it as a just so you know, if we're going to revert back to the prior order, go there, we don't need any of this.
No,
if we're not, then I filed, because of how weird procedurally this is, I filed a clarification and alternative modification to try to cover all the bases. So.
And I think that was good. I mean, but it did give me a little trouble trying to figure out what I was saying. But true, if this is the final order, then that is a component of a motion to modify, really the only component of your motion to modify, which I'm just trying to figure out if we need to have it. Yeah, I'm understand. I think I can handle it. And I've got I've got all the orders, the different orders that you guys have submitted for all the motions that we heard today. So I will get those, but I'll make a ruling if we've just as soon as possible after I've had an opportunity to review a couple of other cases, and I'll get back to you guys. I'll send it to you. Okay.
Thank you, Judge. And just to remind the court, you have until May 13th that the court has plenary power.
Right. Thanks. I thought you were going to say to make those findings a fact that you cannot make. But anyway, okay. Well, thank you guys so much. The sheriff might be calling you to take some statements about the whole sitch from earlier, but I'm just kidding. But I am going to report it, and I'm sorry that happened. Anyway, if anybody remembers their name or one of the people who were here today to contact one of you guys with a name, just let me know. I would really appreciate that, because I don't think we can let that go, right?
No, I know. That was the first. So.
Yeah, I may be getting my YouTube channel over.
I was going to say, hopefully the last.
That was direct contempt.
Yes, exactly.
Times, however many people were on this call. Okay.
Judge.
Yeah.
I wrote down everybody's names in the beginning, and the only person we're missing is a Shannon Best. If anybody knows who that was, but that's the one that's missing.
Was it Shannon Best?
Shannon Best.
You know, my brain flashed up. His name was on the screen, but I was trying to avoid it also, but just find his name on the list, and it's completely gone from my brain.
I bet Zoom can help.
Huh?
I bet Zoom can help because they're trying to remedy this Zoom bombing.
I'll report it.
Oh.
I bet
Okay. All right. Well, thanks. Thanks for that. If anybody else has any more info, let me know, and we will adjourn the meeting.
Thank you, Your
Thank
Honor.
you, Judge.
Thank you, guys.
Thank you. Bye.
Bye.
Bye.